Thank you, Madam Deputy President. Before the state election in March 2023, the former Premier, the Honourable Dominic Perrottet MP, made history as the first leader to pledge the passing of a law prohibiting damaging gay conversion therapy should he be re-elected as Premier. The then Premier Perrottet articulated his determination to eradicate harmful gay conversion practices, citing methods such as electroconvulsive therapy and food deprivation as examples. He pledged to ensure a fair and equitable approach in crafting any legislation on the issue. During the election, the Liberal Party's stance was centred on striking a delicate balance between prohibiting detrimental practices and safeguarding essential freedoms. I've received numerous correspondence and met with various individuals and organisations who feel very strongly about this bill, and I want to thank them for taking the time to explain their views and concerns. It is unfortunate the government has refused to give other organisations and the public the opportunity to thoroughly consider the bill in detail, rather than rushing it through at the 11th hour. Frankly, it's undemocratic and leaves little time for members to review the legislation or consult more broadly with the community to hear their concerns or voice their support for it. If the Coalition initially led the charge on this issue, it seems that they've been excluded from the legislative development process by the Minns Labor government. From the government standpoint, the prospect of bipartisanship, both on this matter and others, dissipates following the state election. The approach of conducting consultations on the bill behind closed doors with select stakeholders has been unfortunate. This opaque method underscores a growing pattern of lack of transparency from the Minns government across various areas. Despite questions being asked of Labor, we still don't know which groups were consulted, and I understand there are many that were asked to be included but were not. Some stakeholders, notably absent from consultation process, included LGBT Alliance Australia, Christian Schools Australia, Australian Association of Women's Schools, Australian Feminists for Women's Rights, and several more. Correspondence received from Rachel Wong from the Women's Forum Australia states, and I quote, "We received no feedback at all from our submission, and we were not invited to participate in any of the closed roundtable meetings that were conducted, despite our clear community interest regarding the proposed bill. Unlike what has been the case for a very small select group of stakeholders, neither were we provided with any draft bill for review. We understand that there are other women's groups, as well as children, parents and LGBT alliance groups who similarly found themselves shut out of the consultation on the bill." Labor's decision to carry out secretive closed-door consultation highlights that more than half of the elected representatives in this parliament, including all members of the Coalition, were left out of these discussions and were never provided with a draft version of the bill at any point. Such an approach is extraordinary, particularly for a minority government. It means that the Liberals and National only had sight of the bill less than a week ago when the Attorney-General tabled it and commenced his second reading speech in the Legislative Assembly on the afternoon of Wednesday the 13th of March. This timeline effectively gave the opposition less than 4 clear business days, including only 2 parliamentary sitting days where other legislation were being discussed to engage on the bill. This time frame encompasses discussing the bill among colleagues, gathering community feedback and formulating a position to present in this chamber today. The government is intent to expedite the passage of this legislation through both houses of Parliament this week. Many will be enacted about a week after it's first been made public to the opposition and to the general public. This rushed timeline is undeniably unreasonable and undemocratic and frankly arrogant. It has left insufficient time for the community to review the legislation, consult with their local members of Parliament, as expected in a representative democracy. It leaves insufficient time for members to gather feedback from communities they represent. It's not just residents of coalition electorates who have been grudgingly disappointed with this situation. Members of the community residing in Labor's electorates should also be gutted that their representatives are part of a government that has imposed an unreasonable timeframe, preventing proper public consultation. Public consultation serves as a vital avenue for gauging community perspective on legislation. Whether it's regarding concerns that are being proposed, measures may not go far enough, or that certain rights may not be adequately protected. Earlier this week, on Tuesday, the Legislative Council Selection of Bills Committee made a decision to refer the bill for an inquiry, a move supported by the opposition. In this context, such an inquiry would have afforded greater opportunity for thorough consideration, public engagement and scrutiny of potential amendments to the bill. However, the Premier decided or directed his colleagues in the Labor Party in this chamber to align with the Greens and thought any opportunity for an upper house inquiry. This decision underscores the Minns government's determination to sidestep proper scrutiny of its legislation, to sidestep transparency and to sidestep accountability. Members of diverse religious communities, including Christian, Muslims, Hindus and others, representing our culturally rich society, are trying to understand how this legislation may affect their freedom of faith. They seek assurances that their cultural values, religious teachings and practices will be respected, and that adherence to their beliefs will not be subject them to unintended legal consequences under the bill. Furthermore, many non-religious groups and community members are also trying to understand how their families and freedoms might be impacted by this bill. For example, the definition of the term suppression contained in the bill is undefined, which could concern most people, particularly parents who may wish and should be able to discuss any topic with their child without interference by government. These dynamics highlight the complexity of the issues at hand and the need for thorough examination and consideration to ensure that the legislation adequately addresses the diverse range of perspectives and concerns within the community. The Attorney-General's stance of rejecting amendments suggests a belief in a bill's perfection, disregarding the possibility of improvements through alternative perspectives on its wording and construction. However, legislation is not infallible and can benefit from input to refine its effectiveness. Given the significant impact of this bill on people's lives, it's imperative to ensure it is robust as possible. Drafting legislation presents significant challenges, particularly in carefully delineating the definitions of conversion and suppression practices. It must address the delicate balance of safeguarding religious speech and teaching while ensuring that sincere, albeit imperfect, conversation between parents and children rooted in love and good intentions are not subject to prosecution. It's strikingly ironic that despite the government's desire for initiating a number of reviews and inquiries, some of which endure for a year or more, this particular legislative process will conclude within just 1 week. This is despite the bill having been delayed commencement of a 12-month after its assent. This rapid timeline appears to prioritise political manoeuvring over genuine consideration for the people of New South Wales, or the fundamental purpose for which this parliament was established, to represent the interests of the public and hold the government accountable. Labor have already commenced a review of the Anti-Discrimination Act, a process expected to span well over a year and remain active for several months. Notably, certain aspects of the Conversion Practices Bill are entwined within provisions of this law, yet the former is slated in the passage well advanced, not within a mere week. This discrepancy raises concerns of hypocrisy and unwarranted haste. While the government appears to have consulted with segments of the community that are highly supportive, it has sidestepped engagement with other groups and evaded dealing with challenging questions surrounding the bill. Organisations such as the Women for Australia and the Australian Feminists for Women's Rights have strongly advocated for the removal of gender from the bill, a request that merits consideration. Unfortunately, due to time constraints preventing me from delving into the details and substantive concerns that have been shared with me and others regarding the bill. However, I note my colleague has indicated we'll be moving a number of amendments in the committee stage, and these amendments are crucial. I urge the Labor Party to remain open-minded with their approach towards the amendments that are being put forward by the opposition. It is imperative that we strike a balance needed that will serve our community as a whole.